Okay. So you talked about soft law. So I'm guessing there must be a hard law as well. What's the difference between soft and hard law in this context?
So that goes back to a discussion of different regulatory forms earlier. So we typically talk about hard law as being your top-down formal law, such as legislation.
Okay.
Right? Legislation, model laws, for example, the UNCITRAL, United Nations model laws would be examples of hard laws. And on the other end of the spectrum, you'll have instruments like codes of conduct for mediators. You'll have the mediation rules of various dispute resolution organizations, such as the ICC. You'll have, in the example of triggering, you'll have like mediation pledges, right? Where, for example, the Lawyers Association, whether it be the Law Society or the Bar Association or a corporate group, will pledge to use mediation in appropriate circumstances. So sometimes examples of soft law, for example, the pledge, aren't strictly legally binding, but they do an enormous amount to incentivize people to use mediation and effectively act as a trigger. Even mediation clauses sometimes, every time there's a mediation clause, it doesn't go to court for the court to interpret whether it's been appropriately drafted and whether it's enforceable. So, there's going to be a lot of clauses probably out there which are technically not enforceable for some illegal reason, but because they're there, they will effectively trigger the mediation process.